All right, let's talk about testing. So, as we talked about earlier, TSCA requires manufacturers and processors to test their substance to make sure that they can measure any risk to humans and the environment. And TSCA provides the EPA with the authority to get this testing data. So this is, pretty technical stuff, and it's very scientific and sciencey and all of that. So they have a committee of experts that was appointed to make recommendations to the EPA, after reviewing this testing. So they look to specific, it's called the Interagency Testing Committee. And it was created to make recommendations concerning them. And some items that deserve special consideration are risks to cancer, birth defects, or genetic mutations. And if the ITC identifies a chemical on the TSCA inventory with these kinds of potential problems, they put it on what's called the TSCA priority list. So the ITC puts one of these potentially bad chemicals on the TSCA priority list. And then EPA, once it's placed on this priority list, they have 12 months to either act on, limiting it or controlling it, or explain why it hasn't acted. Okay? And then there's something called the Preliminary Assessment Information Rule. So manufacturers, when one of their chemicals is on the ITC priority list, they have to submit their information on production and exposure data. So if you look on page 245, these are things that the ITC looks for before putting chemicals on the priority list. So how much is manufactured and or introduced into the environment, the amount of human exposure, whether this substance is similar to any other chemical known to be harmful, and any data concerning the effects of the chemical. Okay. So, test rules for manufacturers or processors to test their chemicals. They can either be based on risk or based on exposure. So if the EPA needs testing to determine the risk associated with the chemical, they use the testing to make a risk determination after finding that a chemical it's very circular. Does the chemical pose an unreasonable risk to humans or the environment? Is the existing data adequate to predict risk potential? If it's inadequate, then maybe you need these additional testing. And the testing is necessary to obtain data on potential risk. If any or all of the above are present, there's a risk trigger, and then the EPA can require testing. So if they find that there is a risk to this chemical, they can impose testing requirements. Okay, the other one is an exposure-based testing or exposure-based trigger. So if a chemical is produced in substantial quantities and it's expected to be released into the environment in substantial quantities, and what the data out there is insufficient to predict what risk would happen, then testing would be necessary to obtain the data to analyze the potential risk. So we have testing rules can be implemented on basis of risk or basis of exposure or potential exposure. If one of the triggers is met, then EPA publishes a test rule for that substance. Okay, and then anyone who is producing that substance must conduct the tests. And the testing rules have been upheld by courts. like in this Chemical Manufacturers Association versus the EPA case on page 247. So the exemptions to the test rules are if, so you're like, maybe I produce this chemical, but it's only a small amount, then you might not have to conduct the testing. Or the substance you're making is similar to another substance where they already have this testing data. And if the entity is exempted, they may still have to kick in money to pay testing costs that another corporation is doing. If not, then the EPA can reimburse them. Testing rules are subject to judicial review. You don't need a separate standing requirement. So that was something else that they talked about in this case. Okay, so for record keeping, EPA keeps all the TSCA records and it uses them for other activities. Any record of significant adverse reaction to a chemical must be reported to the EPA. Any employee reactions are kept for 30 years and others are kept for 5 years. So the kind of reactions that need to be reported are, any change in the composition of animal or plant life after exposure, abnormal number of deaths of organisms, reduction in the reproductive rate of a species, or changes in the behavior or location of a species. So those all sound like pretty bad. They call that a record of a significant adverse reaction. So if the testing shows a significant risk, then the EPA has to issue rules to regulate the substance. So limit it, control it, I don't know, they have to do something, or say why they haven't done so. And they must publish that in the Federal Register so the public has notice. If the EPA determines substantial risk, it has to. So it has 180 days to determine what it's going to do to regulate that substance. Okay, if the EPA determines that the manufacture, use, or disposal of existing chemicals are presenting an unreasonable risk to human health or the environment, they must, it's not they can, they must initiate rulemaking concerning that chemical. So things that are examples of that are asbestos, CFCs, which I don't really know what CFCs are, hexavalent chromium. That was that substance in the Aaron Brockovich case that was in the groundwater, which was causing birth defects and other sorts of bad things. Metalworking fluids and PCBs. PCBs were like a substance used as like I want to say like an oil or something like that for manufacturing equipment that were found to be like super duper carcinogenic. And now you don't make them anymore, but they still like exist in the world. So you can look on page 252. Many are generally aware that PCBs are dangerous substances. But the EPA has been successful in regulating the manufacture, use, and disposal of it. Asbestos, they regulated it in corrosive proof fittings versus EPA. All that good stuff. What's this? EPA only restricts 9 chemicals on the Business Insider. Out of thousands, they only ban 9 chemicals. PCBs. They're toxic to humans, animals, and some plants, and they build up in the environment. Well, that's bad. They were used in these electrical equipment, some sort of like lubrication or oil. I can't really remember. Okay, so then don't drink it, don't swim in it because there's PCBs. Chlorofluoralkylanes. Oh, these are aerosol sprays. You guys are probably too young to remember that these things in aerosol sprays were reducing the ozone layer. Now they're banned. dioxin, like Agent Orange from Vietnam. They cause cancer. It's bad stuff. Asbestos, that causes lung injuries. This is the hexavalent chromium. Some nitrates. There you go. Those are banned substances. Yeah. Okay, here it is. So PCBs was a coolant fluid, and it was around. It lasts a long time. So their half-life is super long. So even though they banned production of it in 1978, it's still around, and it is a known carcinogen, at least animals, but probably humans as well. So those are your banned chemicals. Inspection. So Section 11 of TSCA allows the EPA to inspect establishments where chemical substances are. Remember, this was in the beginning, we talked about that they can inspect or issue subpoenas for documents or to go on site. So manufactured, processed, stored, or held, as well as conveyances used to transport such substances. And the inspections would cover the site, records, files, papers, processes, controls, everything. Anything relates to TSCA. They don't need a search warrant. If somebody is denying them right, they can get themselves a search warrant. But most entities don't really ask for a warrant because they think that looks suspicious, which it probably is. And they usually give notice that there's an inspection coming up. So enforcement, there are different factors that influence the imposition of civil penalties. So what's the violation? What's the circumstances around it? How bad? How serious? What did the violator do? What's their prior history? What's their financial situation? And any other factor as justice requires. So they can look to all those things before imposing penalties. If actions are willful or repeated, there will be more severe penalties. And then there is a provision for criminal penalties in cases of knowing or willful violations, which imposes both prison time or severe fines. And corporations, not just individuals, can be found criminally liable. And there is a provision under TSCA that any person believing violations of TSCA have occurred have the right to a suit. So citizen suits are allowed under TSCA. In 2016, there were amendments. Frank Laudenberg's Chemical Safety Act for the 21st century that require the EPA to evaluate the safety of existing chemicals in commerce, starting with those most likely to cause risk. They require these risk-based chemical assessments. They empower the EPA to require development of chemical information necessary to support evaluations. They establish deadlines that are actually clear and enforceable. They start limiting unwarranted claims of confidentiality and allow for appropriate sharing of confidential information within states and health and environmental professionals. And then it's additional funding to the EPA to carry these things out. So really what has happened since 2016. They finalized the new rules. They reset the TSCA inventory. Now it says 40,000. I saw 68,000. So I don't know what the truth is there. There's some inactive on that one. So that's why. And that will help. Making the list shorter should help the EPA prioritize how it can evaluate existing active TSCA chemicals, fee information, and identifying the next set of candidates to undergo full risk evaluations. Okay, the other thing that's in this text is some information on the Bhopal disaster in 1984 in India, which was terrible. So please read that part, and then you'll see in the learning module there's a video about the Bhopal disaster that I'd like you to watch. All right, so don't forget to study for your test, do your quiz, do your Cali lesson, and I will be chatting, and then there's a written assignment, and I will be chatting with you in 2 weeks.